Morning, everyone. I'm Peter Bennett. This is Huynh.
Hi.
We're doing a presentation on apportionment and contribution. The proposal is to look at a handful of cases, including some odd cases that hopefully explain some of the concepts. The topics we're looking at is contributory negligence, which is a reduction for the plaintiff's claim because of the fault of the plaintiff. We're looking at a couple of cases on failing to keep a proper lookout, some examples of recent cases on intoxication, and the statutory requirement for a finding of at least 25% contributory negligence. Looking at also at contributory negligence, how it can reduce a claim by being determined at 100%, and how contributory negligence applies in contract. That's if the contract claim sounds like a claim in negligence. Then we'll be looking at the defendants and cross-claimants and joint tortfeasors, and where a judgment against a defendant can then prevent another defendant from cross-claiming against that defendant. And then proportionate liability, which applies to claims for property damage and economic loss, where a defendant names someone else as a wrongdoer, and the plaintiff then has to make the decision of whether to join that party as a further defendant to the proceedings. Finally, we're looking at the liability of an employer for a hire worker. That can reduce a plaintiff's claim if the plaintiff was injured during the course of their employment, and it could also be a claim for contribution where a defendant sues the employer of the plaintiff. So firstly, contributory negligence, what is it? The defence of contributory negligence is based on the proposition that each person is responsible for their own safety to a certain degree, and that when their conduct falls below the required standard, they are legally liable for contributing to a situation in which they were injured. Contributory negligence at common law is before the 1965 statutory provision, provided that it was a complete defence to the plaintiff's claim. One of the earlier claims, and I think it's probably the second or third claim for contributory negligence, is from 1809 and involved Butterfield and Forrester. The plaintiff was thrown from his horse and injured after striking a pole. The pole had been put across the roadway by the defendant, who was a builder doing some renovation to his house, and put a pole across the roadway. The court held that if the plaintiff had not been riding very hard, he might have observed and avoided the pole. They held that the plaintiff cannot recover damages for hitting an obstruction caused by the defendant if a plaintiff using common and ordinary care would have avoided the obstruction. One person's fault will not dispense with the plaintiff's duty to use ordinary care. The case was explained as the last clear chance doctrine. The plaintiff had the last clear chance to avoid injury. The defendant was negligent, but there would have been no accident if the plaintiff had exercised ordinary care. We're a bit ahead of ourselves with the slides. The 1965 law reform provision amendments allowed for the contributory negligence. So rather than defeating a plaintiff's claim, it allowed the court to reduce it to the extent that the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. With contributory negligence and apportionment of liability, it depends not only on the fault of the parties, but the degree of importance of the acts in causing the damage or injury. In Predrevesek and Australian Iron and Steel from 1985 in the High Court, the court held that the making of apportionment as between a plaintiff and a defendant of their respective shares in the responsibility for the damage involves a comparison not only of culpability, i.e. with a departure from the standard of care of the reasonable person, but of the relative importance of the acts of the parties causing the damage. Watt and Brightag, which was 1982 from the High Court, explained that in relation to motor vehicle accidents. The speed and size and weight of the vehicles in contributing to the severity of the damage should be taken into account, not merely those factors which contributed to the collision. An example is where there's a collision between a semi-trailer and a bicycle. Even if the driver and the plaintiff rider made equal contribution to causing the collision, it would generally be just and equitable to reduce the plaintiff's damage, not by half, by much less. Similarly, excessive speed may greatly increase the damage, even though the fault of the other driver was the major cause of the collision. So if you have a claim between a reckless push bike rider and a truck, the truck being likely to cause much more damage than the push bike rider would have a greater share of liability. A pedestrian in a car, the driver of the car has a greater liability because their damage, or at least the chances of them causing greater damage, is much more significant from the pedestrian. Linda's now going to look at some cases on failing to keep a proper lookout and intoxication.
Bill, next slide. So, failing to keep a proper lookout. A defence of contributory negligence is based on the proposition that each person is responsible for their own safety. In circumstances where the plaintiff has failed to observe or keep a proper lookout for their own safety, there could be a reduction in the plaintiff's damages. Although the plaintiff was ultimately unsuccessful in the case of Jackson and McDonald's Australia because he failed to establish causation, the court did consider the plaintiff's failure to observe a wet floor sign and failure to use the handrails would have amounted to a reduction of 70% for contributory negligence had he been successful. In this particular case, the plaintiff, Christopher Jackson, had slipped in the Sydney George Street McDonald's and fallen down the stairway at the entrance of the restaurant. He alleged that he and his companion, Mr. Hodson, had entered the McDonald's and then decided to leave, walking through a recently mopped area. He then slipped and fell down the stairs. At first instance, the district court determined that slipping on an obviously wet floor with signs warning that it was wet was an obvious risk. Whilst the Court of Appeal predominantly dealt with the issue of liability, it was determined that if the plaintiff had succeeded, there would have been a reduction of 70% for contributory negligence, as the plaintiff knew the floor was wet and a reasonable person in his position would have taken greater care. Another example of the reduction for contributory negligence for failing to keep a proper lookout is seen in the case of Fitzsimmons and Coles Supermarket. It's the previous slide. Ms. Fitzsimmons slipped on a wet floor of a Coles supermarket, despite the bright yellow wet floor signs posted around the puddle of water that she ultimately slipped on. Ms. Fitzsimmons was hurrying through the aisles looking for a birthday cake for her daughter. She had a baby perched on her hip and was also arguing with her partner on the phone and failed to see the wet floor signs. At first, the district court dismissed her claim, finding that the supermarket had taken steps to warn its customers of the wet floor by pasting 3 yellow warning signs. On appeal, Ms. Fitzsimmons argued that the supermarket should have had a staff member guard the area. The Court of Appeal decided that despite Coles having placed 3 wet floor signs, the signs were too low laying and outside the normal vision of customers looking at the shelves and not the floor. Coles bore 50% of the liability and the plaintiff's damages were reduced by 50% for contributory negligence for failing to heed the bright yellow signs around the puddle. What is interesting about this case is that evidence of the plaintiff wearing thongs, carrying a baby on her hip, and being distracted by the items on the shelves were not factors that the court determined made her contributory negligent. I apologise for the noise going on behind me. And the final case in relation to proper lookout is Hamilton and Duncan. In Hamilton and Duncan, the plaintiff and his co-worker were delivering timber to the defendant. They'd parked in front of the defendant's premises, and as the plaintiff walked around the back of his truck, he stepped into a hole and injured himself. Ironically, just before the incident, the plaintiff had warned his co-worker of that very hole. His co-worker gave evidence at the hearing that the plaintiff had pointed to the hole and said words to the effect of, "There is a bit of a hole there." The court stated that the plaintiff was 30% contributory negligent for not taking reasonable care with the hole that he was aware of. The defendants as the occupiers bore the remaining 70% for their failure to inspect the area and fill the hole. Yeah. The reduction for contributory negligence pleaded in a defendant's defence may result in a 25% or more reduction in the plaintiff's damages if it is determined that the plaintiff was intoxicated. The relevant section in New South Wales under the Civil Liability Act is Section 50. This section applies when it is established that the person whose death, injury or damage at the time of the act or omission that caused the injury or death was intoxicated to the extent that the person's capacity to exercise reasonable care and skill was impaired. It essentially provides that the court is not to award damages in respect of liability unless it is satisfied that the injury is likely to have occurred even if the plaintiff had not been intoxicated. If the court is satisfied that the injury, death or damage is likely to have occurred even if the person had not been intoxicated, then it is presumed that the person was contributory negligent. Of course, the court may determine that the intoxication did not contribute in any way, but it will be an uphill battle for the plaintiff to make. The presumption is that if there is contributory negligence when it comes to intoxication, then the court must assess damages based on a reduction of at least 25% or more. If the court cannot conclude that the plaintiff's intoxication did not contribute to the injury, then the presumption under section 50, subsection 3 applies. This was the case in Jackson and Lithgow City Council. Next slide. In Jackson and Lithgow City Council, the plaintiff, Craig Jackson, was found laying unconscious in the concrete drain in a park in Lithgow. He had sustained serious injuries and had no memory of how the accident occurred. There were also no witnesses. He sued the local council, who had the care and management of the park, alleging that he fell over the low, unfenced retaining wall of the drain and down approximately 1.5 metres into the concrete drain. The trial judge found in favour of the defendant, determined that whilst the defendant had breached their duty of care, the plaintiff could not establish how the injury occurred and therefore could not find the plaintiff stumbled over the wall. The plaintiff appealed, and the main issue that the Court of Appeal dealt with was whether the evidence permitted the court to draw an inference that the accident occurred as inferred by the plaintiff. The report of the ambulance officers held significant weight here. Relevantly, the Court of Appeal upheld the trial judge's finding that the plaintiff was clearly intoxicated at the time of the accident, which gave rise to a presumption of contributory negligence. The court could not conclude that the plaintiff's intoxication did not contribute to the cause of injury. Therefore, the statutory presumption of contributory negligence of 25% applied. I'll now hand it over to Peter, who will take you through how contributory negligence can defeat a claim by being determined at 100%.
Thank you, Linda. The Section 5S of the Civil Liability Act allows for a court to reduce a claim by 100% for contributory negligence, although that's probably never going to occur because in those cases the defendant is normally going to be successful in the claim anyway. It's probably more likely that there could be a claim for a reduction of up to 99%. With the final report that led to the recommendations for the Civil Liability Act commented that our view is that while cases in which it will be appropriate to reduce the damages payable to a contributory negligent plaintiff by more than 90% would be very rare, there may be cases in which such an outcome would be appropriate in terms of the statutory instruction to reduce the damages to the extent the court considers just and equitable. The sort of cases that they had in mind is where the risk created by the defendant is patently obvious and would have been avoided by the exercise of reasonable care on the part of the plaintiff. Courts prefer the defence of contributory negligence because it enables them to apportion damages between the parties, thus allowing the plaintiff to recover something, even in cases where the plaintiff bears a very significant share of responsibility for the harm suffered. Two cases on the reduction for contributory negligence of 100% is Watson and Meyer, another case of Richard and Mount Druitt Workers Club. Watson and Meyer involves 3 horses. There's a mare, which was in season, and then 2 stallions. The plaintiff who placed the mare, plaintiff at least knowing the mare was in season, but placed it in a paddock, hadn't told the defendant, and the defendant was her boyfriend. The plaintiff and the defendant then went off riding their stallions. The stallions, of course, were excited by the mare that was in season. The defendant's stallion threw him off his horse and then went and bit the plaintiff on the leg. The allegations of contributory negligence included that the plaintiff failed to inform the defendant that her horse was in season, the plaintiff failed to avoid riding her horse in the company of the defendant's horse in the direction or near where the horse in season was kept, and the plaintiff had failed to advise or warn the defendant not to ride his horse in the direction of near where the horse was in season. The claim failed. The defendant was 100% successful, but the court, in the District Court, Judge Gibson, still considered Section 5S and the reduction for contributory negligence. She considered that the plaintiff was wholly responsible for the decision to put the 2 mares in the arena paddock in which she and the defendant had been regularly riding for the past 8 months. She was the owner of the property, she was responsible for the transfer of these mares, which were her property, and she formed the decision to put them in the paddock without consulting the defendant. The defendant was absent from the property and would have had no way of knowing that either of the horses was in season unless he was told by the plaintiff. It seems from the case that the plaintiff knew the mare was in season but did not know the risk of stallions being excited. The defendant knew the risk of stallions being excited near a mare in season but did not know that the mare was in season. The case went back to the Court of Appeal, the case went to the Court of Appeal and they referred it back to the District Court, but that was on the judge's findings in relation to credit of the plaintiff, and some conversations as to the knowledge of whether the horse was in season or not. Another case on the reduction for 100% contributory negligence is Richardson and Mount Druitt Workers Club. And this claim involved a person trying to get back into the club climbing over locked gates because there was no easy access to the club. In this case, I've picked the allegations of negligence that the plaintiff alleged against the club rather than the allegations of contributory negligence, but I think the allegations that the plaintiff makes kind of suggest that the accident was caused by the plaintiff's own fault. His allegations of negligence included that it was the first time the plaintiff had found the gate closed and locked, which really doesn't explain why the plaintiff would climb over the fence. The main entrance to the club premises was closed and the only open entrance was on the other side of the building, which was signed no pedestrian access, but it was not alleged that there was any physical restriction on its use. The defendant knew that the patrons would expect to use the rear entrance of the club. Steel bollards were in place close to the gate, and those bollards allowed the plaintiff to climb the bollards, to climb over the gate. It was raining, they were slippery, and because it was constructed of metal and wet. The defendant failed to ensure that the gate was not locked before closing time and to provide an open pedestrian rear access for the use of the club patrons. The defendant placed the plaintiff in a position where the only means of egress available to him was to climb the fence, which is clearly wrong. There was another exit to the place, another entrance to the club. He would have had a mobile phone, could have contacted the club. There's many other steps the plaintiff could have taken, including not even going to the club, just to avoid climbing over the fence and being injured. In the Supreme Court, it was held. There was judgment for the defendant, but they still considered the 100% reduction of contributory negligence in the alternative. The court held that the plaintiff's contributory negligence was 100%. The plaintiff's injuries must be regarded as entirely resulting from his own foolish decision to climb the gate, an action which would have been obviously dangerous even in daylight, but which must have been more obvious at the night and in the rain. In both those cases, the plaintiff's claims failed and the finding of contributory negligence was unnecessary, but just an alternative finding which the lower judges of the district court or the Supreme Court would find. If the plaintiffs are 100% negligent for their own loss, then they've also lost. The defendant or any negligence by the defendant has caused or contributed to the plaintiff's injuries. Just apologising about that noise in the background. Next, a quick look at contributory negligence in contract. At common law, as we discussed before, contributory negligence was 100% offence to a claim. That was then changed in 1946 by the Law Reform Miscellaneous Provisions Act, but that didn't extend to contract. In a case of Ostley and Austrust in 1999, the court found there would have been contributory negligence, but the statutory scheme at that stage did not allow for a reduction for contributory negligence, and that was changed after this decision. But it explains how contributory negligence applies in contract. And that is that it's an implied term of reasonable care in a contract of professional services arises by operation of law. It's one of those terms that the law attaches as an incident of contracts of that class. It's part of the consideration of the promise of pays in return for the expressed or implied agreement or the promise to pay for the services of the person giving the promise. Unlike the duty of care arising under the law of tort, the promise in contract can always gives consideration for the implied term, and it's a term that the parties can contract out of. So contributory negligence might apply to a claim in contract if the claim is based on a breach of the contract term. It's where the contract claim looks like a claim in tort. Some examples would be a lease where the landlord is required under the lease to maintain the property. If you are suing the landlord, the allegation would be that the landlord breached the lease by failing to properly maintain the property. It's similar to the proportionate liability provisions of the Act, which applies to a claim for economic loss or damage to property in an action for damages, whether that action is in contract, tort, or otherwise, and it arises from the failure to take reasonable care. So in a claim of a contract, if the term sounds like it's a tort claim, so it's an allegation that it's breached because of the defendant failed to, or the plaintiff failed to take reasonable care, then contributory negligence can apply. It won't apply to a contractual right for an indemnity, so where a contract provides that someone must indemnify someone regardless of fault. But if it's an allegation that appears to be similar to a breach of duty of care, of wanting care, then contributory negligence can apply. So building works from the building. Next, moving from contributory negligence to Tortfeasor, which is where there's a contribution It was a contribution by another defendant. Just quickly looking at the case of James Hardy and Selson. In this case, it's an asbestos case where there were several defendants, and the plaintiff got judgment for one of the defendants. So a tortfeasor is someone that's a wrongdoer that's caused or contributed to a plaintiff's loss. So if the plaintiff enters a judgment for that person, then the plaintiff is conceding that that person is not liable, not a tortfeasor. In James Hardy and Selson, it was found that the entering of judgment in favour of that defendant prevented any of the other defendants from alleging that they were a joint tortfeasor. The plaintiff found that they weren't, and it entered judgment, so the other defendants could not say that they were a person in respect of that loss that caused or contributed to the loss. The relevant issue is that if there's multiple defendants to a claim and the plaintiff wants to enter judgment against one of those defendants, the other defendants need to consider, are there prospects of a cross-claim for contribution, especially a joint tortfeasor cross-claim against that defendant. And if that's the case, they should never agree or consent to judgment being entered in favour of that defendant, because it prevents them from then contributing or making a claim for contribution against that defendant. It's covered by the Uniform Civil Procedure Rules, which requires the defendants to consent all the parties to the proceedings to be notified before a judgment or order is entered. Rule 3615 also allows the court to set aside a judgment if it's given or entered irregularly, illegally, or against good faith. So if the plaintiff attempts to enter judgment against the defendant, the other defendants have to consent, or the defendants have standing to have that judgment set aside so they can continue with their claim for a joint tortfeasor contribution from that defendant. Next, we're looking at proportionate liability, which is similar and applies for claims for economic loss and property damage, but it does not apply to claims of personal injury. So with proportionate liability, the defendant does not need to file a cross-claim against the other defendants for a contribution. The defendant merely just alleges in their defence and sets out fully in their defence why they think another person who may not be a party to the proceedings is responsible for the loss that the plaintiff has suffered. It only applies to property damage and economic loss, and it doesn't apply to personal injury. And the reasons for that was explained in the 1990 New South Wales Law Reform Commission report. The position of plaintiffs in personal injury negligence actions is distinguishable from the position of plaintiffs in other negligence actions. The economic loss for which damages are sought in personal injury actions goes to the plaintiff's ability to pursue his or her livelihood in the physical sense and to the expenses incurred as a direct result of the accident. In cases of serious injury, the unavailability of damages for economic loss will mean that a plaintiff cannot obtain appropriate medical help and care and must rely on the social welfare system for basic living expenses. Damages for economic loss in non-personal injury cases go to a plaintiff's direct financial loss. There is no interference with the plaintiff's physical ability to work and earn money, and therefore no compensation for the loss of this capacity. The plaintiff will not be forced to rely on the social care welfare system and will not require ongoing medical or other care. So in property damage and economic loss claims where proportionate liability provisions apply, the defendant names the other wrongdoer, and then their damages, if they're unsuccessful in the plaintiff's claim against them, is reduced to account for the other concurrent wrongdoers' wrongdoing. And it's up to the plaintiff to join all the wrongdoers to make sure that they get their full recovery for their claim. Until the recent decision from April last year of Woodhouse and Fitzgerald, it was considered that there was no limitation on who you could allege to be a concurrent wrongdoer. In a decision of Holman Webb Lawyers from the High Court in 2013, there was a comment that there is no express limitation on the nature of the claim which might have been brought by the plaintiff against a concurrent wrongdoer. That changed with a case of Woodhouse and Fitzgerald, which was a claim involving the Rural Fire Service. And the Rural Fire Service is protected from liability by Section 128 of the Rural Fire Service Act. The plaintiff and the defendant were rural neighbours. The Rural Fire Service conducted a controlled burning on the defendant's property. A week later, the fire reignited in a hollow tree and spread, damaging the plaintiff's property. At hearing, the court found that the damage to the plaintiff's property would not have occurred but for the negligence of the Rural Fire Service, but they were protected from liability by the Act. The plaintiff contended that the Rural Fire Service, being statutorily immune from liability for the damage caused by the fire, could not be a concurrent wrongdoer. The court considered the comment from the Hunt decision, which is where there's no liability or no limitation on the liability for a claim for a concurrent wrongdoer. They held that to answer the description of a person whose acts or omissions caused that damage or loss of harm, C, one of the defendants, in common with B, the other defendant, must have been legally liable to A for the damage or loss that is suffered by the person. And the Court of Appeal held that the reference in the definition to acts or omissions or act or omission is one which means legally actionable acts or omissions. So there are limitations on who can be a concurrent wrongdoer. In the Civil Liability Act, it doesn't matter that the person is insolvent or can't be located. That doesn't restrict the claim against them. It just means it's an inability to recover any loss from them. But since the decision of Woodhouse, it's now that the plaintiff has to have a cause of action against that defendant. The defendant has some kind of statutory immunity, then that person, they could be alleged as a concurrent wrongdoer, but there'll be no reduction for their wrongdoing because the plaintiff is prevented from covering against them. Final topic we're looking at today is the liability of an employer for hire worker. So this is where a company hires out its employees to work at other premises. So it happens quite a lot with tradespeople, where there might be a team of employees that they send out to work for other trades that are short of staff. It happens in clerical work, it happens in a whole range of industries. So it's where the employer is the person that officially employs the person, and they send them out to a host employer to work. The case of T&T Christie from 2003 explained that the employer, even though they send the worker out to another premises, still normally has around a 25% liability. And as a rule of thumb, that's kind of the starting point for those kind of claims. The explanation for that is from a decision from 1937, which is that the employer has the exclusive responsibility for the safety of the appliances, the premises, and the system of work to which he subjects his employee, and the employee has no choice but to accept and rely on the employer's provision and judgment in relation to these matters. The consequence is that in these relevant respects, the employer's safety is in the hands of the employer. It is his responsibility. The employer can reasonably expect, therefore, that reasonable care and skill will be taken. In the case of the employer, there is no unfairness in imposing on him a non-delegable duty. It is reasonable that he should bear liability for the negligence of his independent contractors in devising a safe system of work. If he requires employees to work according to an unsafe system, he should bear the consequences. So the employer always has a duty to the employee. They're paying the employee's wages. The employee has to do what the employer says. So the employer has a duty to make sure that wherever he's sending the employees to work, wherever he or she is sending the employees to work, that it's a safe system of work and the employee is not being in danger. The employee really has very limited ways of protecting themselves. They have to rely on the employer if they want to continue employment. So in T&T and Christie, it was found it was a 25% duty, and that in that case there was some evidence that the management from the employer, which was Manpower, attended the premises of the host employers, but just had discussions with the supervisors at the premises. There was no evidence there that the employer, Manpower, actually went there and inspected the premises, inspected the work that the employees were doing. Another case is Shoalhaven City Council and Humphreys. In that case, the worker, it's a hire worker working for Shoalhaven City Council, was injured when he was lifting a 75-kilogram manhole cover. And there were different ways of doing it. One person could lift the man cover. They had a T-bar, which could be used by one person. Two people may be required in some cases, or there'd be mechanical lifting devices attached to a truck. In this case, Mr. Gillard, who was the supervisor from the council, failed to follow the council's guidelines on safety and safe lifting methods and hadn't made any inquiries as to whether the injured worker had been trained in proper lifting methods. One of the comments for the case is that the council ran the trial on the basis that Mr. Humphreys, the injured worker, was under its direction and control and that was not negligent. It is unsurprising that it did not, for forensic reasons, advance a case in the alternative that its procedures were so patently defective that the employer was negligent in not seeing that more should have been done. So in that case, the council is 100% liable. If they want to say that Mr. Humphrey's injured worker's actual employer was also liable, they would have to say that the employer, if he came onto their site, would have found that their systems were so bad that they weren't taking proper care of the actual employee while working at Shoalhaven City Council, and that would create a liability for the employer. But in this case, the council had proper systems, it had proper programs, had proper procedures for lifting weights. And so if the employer had gone to the council and to see what kind of work their employee was going to be subjected to, they would have been satisfied that it was a safe system of work. In this case, it was a casual incidence of negligence. So while they had a safe system of work, no one had, and that's the employer had no way of knowing that one of the employees of the council would do something silly or dangerous or put their employee at risk. So even though they had the systems, because in this case it involved the supervisor not following the systems that were in place, it's something that couldn't have been picked up by the employer, and so the employer had no liability in that case. The final case looking at is Pollard and Bolston Hornibrook Engineering. This is one where the plaintiff was injured when he slipped and fell on the surface of a wash bay while cleaning the tyres of his truck and making a delivery of concrete. The relevance of this case is that if you're an employer and you're sending your employee out to a whole lot of different people's properties, so it could be a tradesperson that's going to houses, fixing washing machines or whatever, salespeople are going to a whole lot of different businesses or whatever. How does an employer escape liability by making sure that those premises are safe? It couldn't be expected that the employer will go to each of those premises and buildings and make sure that the systems are safe, especially if it's a one-off delivery or a salesman going to many different places. So in this case, the fact that the appellant was required to visit so many construction sites and dependable, which was the employer, anticipate that there will be a variety of hazards at each site to which the appellant might be sent, underline the necessity to give him adequate instruction and guidance about what to do if he encountered conditions which exposed him to a risk of injury. To discharge his non-delegable duty, the employer had to adopt measures by which way of warning and or training to require persons such as the appellant to report dangerous conditions and to seek instructions as to what to do in the circumstances. So the way the employer escapes liability in those kind of cases is that it has guidelines and procedures in place. So if the employee attends at premises which appear unsafe or dangerous, they either don't attend the premises, they ring up the employer and get guidance, so that the employer has to have some kind of system in place where an employee can notify them of a dangerous condition and also recognise a dangerous condition and then avoid the risk of the injury occurring at the other person's premises. So in conclusion, the basis of our discussion today was to explain some of the concepts involved in apportionment of claims and looking at some of the extremes. So contributory negligence can be 100%, more likely it could be 99%. For intoxication, it's 25%, but in the case of Mr. Jackson, which is the man that fell over the wall, which even a sober person would have fallen over, that seems slightly unfair. For contract claims, if a claim sounds like a claim in negligence, so it's a claim basing the breach of a contract on breach of a duty of care, then there could be a reduction for contributory negligence. During tortfeasor claims, if a plaintiff enters judgment for a defendant, then that defendant isn't liable to the plaintiff and cannot be joined by another defendant as a cross defendant alleging a joint tortfeasor. The tip is to always consider whether to consent to judgment if a plaintiff seeks to enter judgment with one of the defendants. If you seek to have a contribution against them, then don't agree to enter in judgment. For proportionate liability, the most recent case now is that there has to be, the plaintiff has to have a cause of action against the wrongdoer, and if there's a statutory prevention of that claim, then they cannot be a concurrent wrongdoer. For the liability of an employer for an injury to its hire workers and a host employer, the starting point is a 25% liability. It depends on whether it's a casual act of negligence, which could have been prevented by the employer by going out and inspecting the work site. And it's one that could not have been avoided by training, planning by the employer, if it's one that can be avoided by training and planning by the employer, then the employer can't escape liability. thank you all for your time. There's a handout attached to the invitation. If you'd like to download the handout, and contact Linda or I if you have any questions. Thank you.